Hello friends, welcome back to my channel. Continuing with the series important case laws from the law of contracts. Today I have come up with another two very important cases from the law of contracts. These cases are Carlil versus Carbolic Small Ball Company and Mohori Bibee versus Dharmodas Ghosh. So let's start. Starting with the case Carlil versus Carbolic Small Ball Company. This case was of the year 1892. The facts of the case are: Carlil was the plaintiff in this case and Carbolic Small Ball Company was the defendant. The defendant, that is the Carbolic Small Ball Company, produced a new smoke ball to cure influenza. After that, the defendant company published newspaper advertisement stating that if anyone gets sick with influenza even after using the prescribed course of smoke ball, they will be rewarded £1,000. The advertisement also stated that the company have deposited £1,000 with the bank as an assurance. Now, Mr. Carlil, who was the plaintiff, purchased the smoke ball and used it as per the directions, but subsequently Mr. Carlil caught influenza. So, as per the advertisement published by the defendant company, plaintiff Mr. Carlil now claimed £1,000 from the defendant company, as even after using the smoke ball, she caught influenza. However, plaintiff's claim was refused by the defendant company. Plaintiff then filed a suit against the defendant company for the recovery of the amount. The lower court passed the order in favor of the plaintiff. That is, the lower court ordered the defendant company to pay compensation to the plaintiff as per the advertisement. Now, the defendant company went in appeal before the higher court. The question that arose before the court was whether there was any binding contract between the parties. That is, whether the contract was binding and that enabled the plaintiff to claim compensation from the defendant company. The appellate court held that there was a fully binding contract between the parties. The court held that the advertisement by the defendant company was a unilateral offer to the entire world. As mentioned, the defendant had published an advertisement in the newspaper stating that if anyone gets sick with the influenza even after using the prescribed course of the smoke ball that was produced by them, will be awarded or rewarded £1,000. So the court held that this advertisement was a unilateral offer to the entire world, and the satisfying conditions for using the smoke ball constituted the acceptance of that offer. Also, the company's claim that it had deposited £1,000 at the Alliance Bank showed the serious intention of the defendant company to be legally bound. So, the appellate court dismissed the appeal of the defendant company, that is the appellant, and the respondent was held entitled to compensation. That is, the appellate court too concurred with the judgment of the lower court. The lower court had already held that plaintiff was entitled to the compensation because even after using the prescribed course of the smoke ball produced by the defendant company, plaintiff had caught influenza. So, the lower court had held that plaintiff was entitled to be compensated by the defendant company, and the appellate court also concurred with the judgment of the lower court, thereby holding that the respondent, that is the plaintiff in the lower court, was entitled to compensation from the defendant company. Hence, from this case, it can be concluded that the unilateral offer for the sale of goods via advertisement waives of the rule of notification of acceptance, and an advertising scheme with a reward for the performance of any act can be considered as a contractual promise to pay. So, this was all about the case Carlil versus Carbolic Small Ball Company. Coming to the next case. The second case that I will be discussing today is Mohori Bibee versus Dharmodas Ghosh. This case covers the ambit of minors agreement. So, let's start. The facts of the case are: Dharmodas Ghosh was the respondent and Mohori Bibee was the appellant. Dharmodas Ghosh, that is the respondent, was the sole owner of his property. Respondent, that is Dharmodas Ghosh, had secured a loan of Rs 20,000 from the appellant. and the property belonging to the respondent, that is Dharmodas Ghosh, was mortgaged in favor of the appellant, who was the money lender in this case. So, at the time of the transaction, the attorney who acted on behalf of the moneylender, that is the attorney who acted on behalf of the appellant, had the knowledge about the respondent's minority. That is, the attorney knew that the respondent who was a party to the mortgage deed was a minor. Subsequently, what happens is that respondent brought a legal action against the appellant, stating that the mortgage that was executed by respondent was commenced when he was a minor, and as such the mortgage was void and he was not liable to return the loan amount to the appellant. The question that arose before the court was whether the mortgage deed void on ground of the minority of the respondent who was a party to the mortgage. Now, the trial court held that the mortgage deed between the appellant and the respondent was void, as it was entered into by a person who was a minor at the time the mortgage was entered into. It was further held that the respondent, that is Dharmodas Ghosh, was also not liable to return the amount of loan that he had borrowed from the appellant, because he was not bound by that promise under the mortgage deed since it was declared void. So, in this case, the court held that the mortgage which was entered into between the appellant and the respondent in this case was void on the ground of minority of the respondent. Also, the court held that the loan that was borrowed under that mortgage was not liable to be repaid to the appellant. Hence, the appellant filed appeal against the judgment of the trial court. The appellate court dismissed the appeal filed by the appellant and upheld the judgment of the trial court. That is, the appellate court concurred with the judgment of the trial court and held that the agreement, that is the mortgage deed between the parties, that is the appellant and the respondent, was void on the ground of the minority of the respondent. From this case, it can be concluded that any agreement or deed in which a minor is a party to it or is included in such agreement is null and void, because such agreement is not an agreement in the eye of law. So, this was all about the case Mohori Bibee versus Dharmodas Ghosh. In my next video, I will be coming up with another 2 important cases from the law of contract. Thank you for listening, and if you like the content of my videos, please subscribe to my channel and do like and share the videos. Thank you.